Mr. Chair, you have a quorum?
Well, thank you. The way this is going to work is we're going to re-refer one bill. We're going to take up a bunch of bills that are identical or very similar to Senate bills. We're going to take up some bills from House Courts Committee members. We're going to put at the first of the line those bills that have to go to the Finance and Appropriations Committee, and then we'll take the rest of the bills. We're going to get through as many of these bills as we can this afternoon. I expect we're going to have to meet on Monday morning, but only, I'm hopeful we only have a handful of bills then. And the Finance Committee bills will have to be done today. The first one we've got is 1976 from Delegate Bell, which is identical or similar to a bill that I had, 1299, and we're going to re-refer that to rehab, which is going to meet Friday morning. Can I have a motion like that? Motion to re-refer. Okay, is there's a motion and a second to re-refer to rehab. Do we need to vote on that? Vote green is vote to re-refer, because rehab is where this bill went when it was on the Senate side.
Ayes 11, no zero.
Okay. Now that the House bill is identical with Senate, there's some uncontested ones. 1673 from Senator Bell is identical to a bill that Senator Boysko had that related to strangulation. You all probably remember this. It provides that any person who without consent impedes the blood circulation or respiration of another person, you recall, it's a Class 6 felony. There had a fiscal impact. I think this bill has to go to Finance. Okay. 16, we can do them in a block then. 1673, 2024 from Delegate Leftwich relates to, or it's similar to a bill or identical to a bill that I had, 1310, that regard to protecting personal information with respect to judges and magistrates. 2372 from Delegate Wyatt is identical to Senate Bill 1135 from Senator McDougal. It had to do with purchase, possession of catalytic converters. We reported all these bills with the Bell bill was reported 16-0 from Finance, 15-0 from this committee, and the Senate 39-0. The Leftwich bill left here 15-0, and it passed out of the Senate 39-1. The Wyatt bill left here 15-0. It passed out of the Senate 39-0. What I would like is a motion to report and re-refer these three bills in a block.
So moved.
Finance. Okay, got a motion and a second to report and re-refer these three bills in a block to Finance. Please open the roll.
Ayes 12, no zero.
Okay, ayes 12, no zero. The next group of bills I think we'll have to deal with individually because they're House bills that were identical to Senate bills, but they were contested. The first one is 1474 from Delegate Weber. It involved protecting personal information of law enforcement. It was identical to Senate Bill 1004 from Senator Steff that was PBI'd in this committee 9-5. Is there any additional information that could change? Is Delegate Steff not here? Weber, I apologize. Well, let's just save it for him to get here then. The next one is Delegate Walker's 1572, which is, well, this one was a bill that was identical to my 1291. It was reported from this committee 13-2. Reported, I think it has to go to Finance. Is that right?
Yes. Correct, Mr. Chair.
Okay. This was the swatting bill. You will recall this. So a motion to report and re-refer has been made. Please open the roll.
Ayes 13, no zero.
The next is Senator Bell's, or Delegate Bell's 1897, which is what relates to extending protective orders, a preliminary protective order. You'll recall it was identical to a bill that I introduced, 1532, that reported from this committee 13-1, and it will have to go to Finance as well, I think. It passed the Senate 39-1.
Report and re-refer.
Okay, is there a second? Okay, please open the roll.
Ayes 14, no zero.
Okay.
Gotcha.
The next is House Bill 1943 from Delegate Runyon. Is he here?
Yes.
Okay, this is a bill that is identical to Senator Peake's 989, that reported from this committee 11-1 with 2 abstentions. It had to do with a notification of victims of a plea agreement. You may recall this bill. There were 2 abstentions that passed, the Senate 30-10. Do I have a motion on this bill?
Move to report.
Motion and a second to report this bill. Please open the roll. Okay, the next one on that bill's reported.
Ayes 11, noes 3.
The next bill is Delegate Bell's 1954. It's identical to a bill from Senator Obenshain, 1225, that was defeated in this committee, 9-6. Delegate Bell, do you have any information that will change our minds?
I would like 30 seconds.
Sure.
All right, Mr. Chair, members of the committee, this is the bill brought to you, I understand you heard in person from Taylor Shiflett. She was driving home from work when her vehicle was struck by someone who was on a lengthy car chase hit and run. It would add the manslaughter provisions to what we already have for fetal homicide, which tracks the first and second degree. I understand that it was heard before. She is available to testify. I understand that the committee is not taking virtual testimony.
Okay, do you all recall this bill?
Yep, I do.
Okay,
Mr. Chair, I have a motion.
Senator Peterson.
And we did hear this bill and we heard from her and it was a very heartrending story. The problem is you don't have the level of knowledge or intentionality on behalf of the defendant that would, in my opinion, would trigger the statute. So therefore, I move to PBI.
Is there a second? Okay, are there other motions? If not, open the roll. Vote yea is vote to PBI. Okay,
Ayes 10, noes 4.
that's 10 noes for the bill's PBI
Thank
then.
you.
Let's see, the next bill,
Mr. Chairman, can we move to reconsider on that? We're not paying attention to which motion was in front
Senator
of us.
McDougal moves to reconsider the vote by which we just PBI'd 1954. Is there a second to that motion? Okay, all in favor of reconsidering, vote green. Okay, the bill's back before
Ayes
us.
15, no 0.
Okay, got a motion to PBI. Is there a second? Are there other motions? Okay, it was second. Yeah. The motion is to pass by indefinitely. Open the roll, please.
Ayes 9, noes 6.
Okay, thank you, Senator Delegate.
Mr. Chairman, Serba.
Senator Surva.
Thank you. I was just talking with Delegate Adams. He told me he'd like House Bill 2013, which is on page 11, to go by for the day to be heard on Monday. He thinks he might be able to work something out on that.
But 2013 is one of the bills that the Senate Finance Committee's asked for, Senator Survell. And today's the last day.
Okay, I'll go track down Adams.
Okay. Okay, I passed by a bill a second ago. 1474, Delegate Weber. Is he here? Delegate Weber, 1474.
Yes, sir.
This was identical to Senator Steff's bill that was passed by in this committee. If you want a minute or something to tell us why we were wrong.
Well, I don't like telling people why they're wrong, Mr. Chairman. I don't know. I did not follow the testimony previously. I will say that when I was giving testimony to this bill before on our side, one of the biggest things there were some things that came up, but the biggest issue, I guess, the biggest issue as to why the bill is necessary is that, so just to give an example, or the example that was given was, say an officer is doing, for lack of, since I'm not a lawyer, but doing like a traffic summons or presenting evidence where there is no prosecutor handy. The opposition could, ask him for his information, and in that case, he can't object to that because he is not a practicing lawyer. And so basically what this is their form of objecting, where then the judge can come in and say, you can't ask for that information. And that was that was the information that came forward during our presentation.
That's an idea, I guess it wasn't discussed. Most of the time, when there's a pro se defendant, when I've observed cases, the judge kind of acts as a prosecutor and doesn't let objectionable evidence in, but I understand that that's up to the judge, and every judge is a little bit different.
And yes, Mr. Chairman, exactly. And that's the primary reason. So that was new to me, which is the reason it passed on our side.
Senator Sasslaw asked me what was wrong with the bill, and I was just telling him that in most cases, it's not going to be relevant evidence. The question, if you ask a law enforcement officer, that was the testimony before, as I recall, or the argument before. Does anyone else need to address this bill?
I do have DCJS here in case, but like I said, it's not always the case, as you said, Mr. Chairman. I think occasionally you have a judge that won't interject in that case, and that's why we thought it was necessary. But
Okay.
again, it's up to you.
You've got a motion to report and a second. Are there other motions? A motion to pass the bill by indefinitely. Is that motion second? Was that a second? Yes. Okay. So the motion to pass by indefinitely takes precedence. All in favor of a motion to pass by indefinitely, vote yea.
All right.
Thank you.
Thank you, Mr. Chairman.
Thank you. Okay, now we are down to section
Ayes 9, noes 5.
4. They are House bills with Senate companions. Some were contested and some weren't. The first one on the list is 1455 from Delegate Anderson.
Good afternoon. House Bill 1455 is unique as a fentanyl bill. It targets something that is an actual problem in Virginia, the sale of counterfeit pills to unsuspecting buyers. Mostly in college communities, our children are buying Adderall, Zoloft, and what it is
Delegate Anderson, this was similar to Senate Bill 1490 from Senator Vogel. Perhaps you could just focus
Sure.
on the differences between the two bills.
Sure. So this bill is similar to Senator Vogel's, but it has been amended in the House to take out a key component of should have known. This is only addressing dealers that actually know they're selling counterfeit pills to unsuspecting buyers. It narrows it to that actual knowledge requirement, and it's better because of that. That was a House amendment that came from the Courts Committee at that time. So we're targeting just people that knowingly sell counterfeit pills that actually have fentanyl that result in death or possible death to the buyers.
Mr. Chair.
Senator Morrison.
Thank you. Delegate, there's nobody in this room that questions the horrific situation associated with fentanyl. But tell me this, given that you have these controlled substances, whether they're isomers or esters or salts of isomers or any type of rearrangement of those molecules, how does one know or should know that it contains 2 milligrams or more of the fentanyl, especially when drugs are always cut and then cut again and maybe cut again, and then you may add something to it? How would somebody know?
Mr. Chair, Senator Morrissey, that is a defense that certainly can be raised if somebody were to be charged with this. This gives prosecutors a tool to that effect. But what's happening is dealers in Virginia are importing fake pills from mostly Mexico. Adderall, American prescription pills. They know they're fake, they know they're fentanyl, and there's connections of that. Now, I don't think drug dealers would intentionally want to sell a drug per se that would kill their customers. That doesn't equate to repeat business. But that recklessness, that disregard is what this bill is going to address.
Follow-up question.
And it's a minimal amount, as you know. It's grams of salt.
Senator Morrison.
Whenever we have these discussions, we're always talking about the big bad dealer. What about, because any legislation has got to capture and encompass everybody.
Sure.
What about the Virginia State University student who has a pill or this, and then gives it, sells it for a modicum of money to another VSU student at a party, and knows that, or thinks, or is recklessly unaware that it has fentanyl, that person could be charged with attempted first-degree murder?
Not anymore, not under this new, not under, after the substitute from the House. It's only those who knowingly do it. So if it's indifferent recklessness, it wouldn't be there. It would have to be knowing. So if the VCU student buys an Adderall from the drug dealer and then gives the Adderall to her roommate, that person would not be charged under this code. This addresses the person who knows that it's fentanyl that they're selling or distributing. Now, if the VCU student gives it to another VCU student and they know that that pill is not really Adderall but fentanyl, they would get caught up in this.
Final question, Mr. Chair.
Senator Morrissey.
And thank you, Mr. Chair, for allowing me to trespass on the body's time. Isn't that the problem with this bill? You've got to get that, you would be proving in court what the distributor knew or didn't know. Isn't that the problem with this bill, getting into he said, she said on what that distributor, whether it was an accommodation or otherwise, actually knew?
Sure, so that's the question for the prosecutor, right? This is just a tool to give a prosecutor in those cases where they have distributors who are knowingly distributing fentanyl. Not every case is going to be prosecuted under this. There's other ways you can prosecute a dealer. But if I put poison in your soup and I'm a cook, I should be charged with first-degree murder by poison. These dealers that are distributing fentanyl under false pretenses should be treated exactly the same in those circumstances. It's a tool for prosecutors to use.
Mr. President.
Senator Obenshain, then
Mr. Chairman,
Senator Peterson.
we all know this bill and the parameters of it, even the nuances of it. I move the bill be reported.
Mr. Chair, I have a question. I have a question.
Okay, well, they've got a motion and a second
Can
to
I
report, but there are a couple other people that want to speak. Senator Peterson, then Senator McClellan, then Senator Edwards.
Sure. We've had a lot of bills on fentanyl, and one of the ones we did was to designate the distribution of fentanyl as a terrorism, an act of terrorism. So how does this interplay with that? Is it no longer an act of terrorism? It's simply drug distribution? I feel like, we're recriminalizing the same conduct over and over and over and over again. I mean, at one point, what are we doing?
Sure. Mr. Chair and Senator Peterson, there are people that are buying fentanyl, dealers that are selling fentanyl to users. That would be covered under the terrorism provisions that this body has already cleared. What this addresses is the dealers that are selling imitation U.S. prescription pills to unknowing buyers. And those are the people that would get charged with first-degree murder.
Follow-up question, Mr. Chair.
Senator Peterson.
My recollection of the terrorism bill was if you intentionally take fentanyl and inject it, basically sell it to somebody with the knowledge that they're going to ingest it, that's an act of terrorism. It's hard for me to imagine a criminal sanction that could be more severe than that. So it sounds like what you're is almost like a lesser included offense. It's the same conduct. It's intentionally selling fentanyl to an end user to be ingested. I'm still not seeing what the distinction is unless this is intended to be a lesser included offense.
Well, I don't think first-degree murder is a lesser included offense in anything. It's the most primary serious offense you can have. This addresses the unique circumstance of the unknowing buyer buying something that they don't know that they're buying.
But
Now, fentanyl being sold and distributed and all that, whether that's terrorism or not, that's for now, I guess, the governor to decide. This bill addresses the victims who are dying, or children, mostly in colleges, who are dying because they're making a mistake and buying Adderall or some other type of pill.
Okay, Senator McClellan's got a question.
Yeah, thank you, Mr. Chair. Why would not, in the scenario that you outlined, somebody be able to be charged under 18.2-32 with first or second degree murder, which they define as murder to include murder by poison?
Yeah, Mr. Chair, Senator McClellan, that's exactly what this bill is going to do, is allow the incorporation of 18.2-32 into this bill to define selling imitation prescription pills as a murder by poison. It incorporates 18.2-32 into this bill.
But why can't you just, why can't someone be charged for murder by poison now?
It's not, what poison is has not been defined in the code in this context. And so we're trying to make clarifying language that fentanyl as being sold as Adderall in this equation is poison and can be charged as first-degree murder.
Fine.
Could they be charged now? Maybe. It would be up to a court to decide whether fentanyl is poison or not.
Well, Mr. Chair,
Senator McClellan.
I think that at a minimum, they could be charged with second-degree murder, which is defined as all murder other than aggravated murder and murder in the first degree. If a court finds that it is not murder in the first degree because it's not poison, then I believe they could charge with murder in the second degree if they intentionally put fentanyl in an Adderall pill. So I'm not sure we need a separate crime for this.
Okay, Senator Edwards has something.
I had a good chance to meet with some of the victims in my office. I had a long conversation. I'm very sympathetic. And also, I believe, after looking at it more carefully, fentanyl is worse than anything else. It's death. And people are selling it and not understanding what they're doing. I think we probably ought to ratchet up the punishment for just transferring fentanyl. I think the best thing to do now, so I'm on the Crime Commission. I think we ought to pass it by and definitely send it to the Crime Commission to do a study of this and the best way to handle this issue.
So that's a motion to
That's my motion.
PBI, or a substitute motion to PBI with a letter to the Crime Commission. Is there a second for that?
Second.
Okay, I think Senator Morrissey had something after.
I'm going to withdraw my question because
Okay.
of the motion.
So the substitute motion takes precedence. I would ask the clerk to open the roll. A green vote is a vote to PBI
With the letter.
with a letter to the Crime Commission.
Ayes 8, no 7.
Ayes
Very
8, no
much.
7. Thank you. Okay. The next bill is 1478 from Delegate Ballard. That was similar to Senate Bill 1207 from Senator McDougal that reported from this committee 11-4, reported from the Finance Committee 16-0, and passed the Senate 38-0. It expands the definition of acts of violence for gangs, increases various penalties for gang crimes. Got a motion to report, and the second has to go to Finance.
Mr. Chairman, Servo.
Senator Servo.
This says it's similar but not identical. I'm just curious what the difference is.
Okay.
Well, Mr. Chairman, members of the committee, Senator Servell, if you all would like to conform the version that passed out of here to mine, I'm certainly fine with that,
Do you have
move it
any
forward.
objection to make your motion motion to conform? Okay, motion to conform and second, so that'll be a substitute. Do we need a voice vote? Okay. All in favor of conforming to Senate Bill 1207, say aye. Okay, is there a motion to report and re-refer to finance? Okay, is there a substitute motion? I would ask you to open the roll. A vote yea is a vote to report and re-refer to finance. Okay.
Senator McClellan.
Okay, thank you very much.
I have one more
Ayes
bill.
14,
Mr.
no 0, abstentions 1.
You've got one more bill?
Yes, sir, Mr. Chairman. 1892, if you'd like me to take it up now or wait, that's your prerogative.
Are you on the criminal law subcommittee?
I'm not on the criminal, I'm on the civil.
Well, I'm trying to take the conforming bills and then the bills that have to go to finance and then the bills from the criminal law subcommittee first.
That's fine, Mr. Chairman. Thank you very much.
Thank you. Okay, the next bill we've got is the HB 1523 from Delegate Taylor. Is she here? Okay. This is a bill that's similar to Senator Vogel's 1377. It was PBI and Judiciary 8-6. Delegate Taylor, if you could just tell us what the differences are between this and the similar bill. 1377, do you know?
Good afternoon, Mr. Chair and members of the committee. I do not know those exact differences.
Staff can.
Mr. Chair, I can help out. Mr. Chair, Senator Vogel's bill just increased the third offense to the Class 6 felony for soliciting a prostitute, where the House bill goes a bit further. It increases the fines for certain offenses related to sex trafficking from $100 to $1,000 and $500 to $2,500. It also makes it a Class 5 felony to solicit prostitution from any minor. Under current law, it's bifurcated by an age of 16. So it's a Class 5 felony if you're soliciting under 16 or younger, but it's a Class 6 if it's 16 to 18.
So this bill's broader than Senator Vogel's bill?
That's correct, Mr. Chair.
Chair.
Senator Peake.
I'd move to conform this to the Senate version of. Can't we, since it was PBI?
We PBI'd the Senate
We don't
version.
need to, yeah. Don't conform it, all right. Well, this one's worse. Well, this one's chance now.
Well, you might be stating the obvious there, but you never know.
Do we have a meter on the wall?
Move to report.
Got a motion to report and a second. Do I have other motions? Okay, substitute motion and a second to PBI. The substitute motion takes precedence. Open the roll. A vote yea is a vote to PBI. Okay, thank you very much.
Thank you.
The next on the list.
Ayes 9, no 6.
Next on the list is House Bill 1603 from Delegate Wyatt. It is similar to Senator Stewart's 1542, which was PBI'd in here 9-4. So do you know what the differences are? Can you?
No, sir, because I didn't realize you all had one on your side. 1603, repealing sentencing credits.
Okay.
Mr. Chair, the differences are largely technical. In the House bill, it did strike a line that was incorporated into another line, but essentially the bills are the same. I would note that this has a corrections impact of $108 million.
Okay. $108 million. Do you know if this is in the House budget?
Yes, sir, it did pass the House.
But is it in the House budget as well?
I can't answer that question, sir.
Okay.
On the grounds of might incrimination?
Okay. Okay, do you want 30 seconds to just talk about it, or?
This just repeals sentencing credits on felonies that, while incarcerated, and eliminates any earned sentence credits for folks that commit felonies with the use of a firearm. It goes to serve justice for many families across the Commonwealth that have been affected by firearm-related felonies. I pass those individuals each and every day coming in from the eastern part of Hanover, coming through the city of Richmond, as parents and grandparents hover over their kids in the city when a shooting has just occurred a block away on the day before. We've got to do something. This will help combat those firearm-related felonies that are committed across the Commonwealth.
Mr. Chairman.
Okay, Senator Morrissey.
Delegate, does this capture that defendant who was convicted of a firearm offense as a principal in the second degree?
Not, if it is passed, it will, sir, is my understanding.
Right. Further question, Mr. Chair. I'll take that as a yes. If it captures that individual as a principal in the second degree, somebody who did not hold the firearm, did not use it, did not fire it, and he's a 17-year-old juvenile and he gets convicted of these firearm offenses, why wouldn't you want that person to be able to avail himself of earned sentence credits, even though it's a firearm offense, but particularly since he was a principal in the second degree?
Not being an attorney, Mr. Chairman, I would defer to the experience of the attorney. But I would tell you, too many folks are dying across the Commonwealth due to firearm-related deaths, and we've got to do something to protect those folks that I pass each and every day as I travel through the city of Richmond to come downtown.
Thank you.
Oh, thank you very much.
Mr. Chairman.
Senator Servell.
Thank you, Mr. Chairman. You know, this bill doesn't have to do with people out on the street. It has to do with people who are in prison. And Virginia has one of the lowest recidivism rates in America. And the people that the earned sentence credit benefits are people who have followed the rules in prison to get re-educated, rehabilitated, and improve themselves. And I just think that you're misplacing blame in terms of where you see the crime coming from. Having said that, Mr. Chairman, I move to gently PBI the bill.
Is there a second? Are there other motions? Vote, open the roll, vote yea as votes PBI. Okay, thank you, Delegate. You just stay up there.
I do have.
Apologize.
Ayes 9, no 6.
House Bill 1682,
Yes, sir.
which is similar to Senator Reeves' 1188 that reported from this committee, 14-1, reported from the Finance Committee, and then passed the Senate 38-2. It's the bill that defines fentanyl as a weapon of terrorism. Are the differences between this bill and Senator Reeves' bill?
One sentence, Mr. Chairman, on line 46, the Senate added a violation of this section shall constitute a separate and distinct offense. That was not in my House version.
Right, Mr. Chair, that language is in the House version. That sentence is largely unnecessary because there is a section in the terrorism article that says any violation of this article is a separate and distinct offense.
Okay, well then a motion to report and re-refer would be in order.
It should be conformed to the Senate version, which has that language stripped out. So
We took the sentence, okay, I understood that we had the sentence in.
Mr. Chairman, move we conform.
Conform, okay. All in favor of conforming, say aye. Aye. Now motion to report and re-refer.
Mr. Chairman, move we report.
Move to report and
And
re-refer. Finance, okay. Are there other motions? Open the roll, vote yea is motion, vote to report and re-refer. Okay,
Ayes 14, noes 1.
thank you very much.
Thank you, sir, and committee members.
Okay, the next bill we've got is Delegate Byron. Is she here from 1885? It's a bill similar to 1396 from Senator Stewart, 1296 from Senator DeSteffe. I think Senator McDougal had a bill that was close to this too. Both of those bills reported, or they were combined and reported from this committee 14-1 and passed the Senate 38-0. So what are the differences, Charles?
The only difference is that mine still has the third offense, petty larceny in it. Yours did not.
Right, Mr. Chair, there are a couple differences. One is the third offense, petty larceny. The other difference is that the Senate version changed up some of the elements, so it required somebody to conspire or act in concert with another one. This bill still does not have that elemental change.
Second.
Motion to conform
That's
and a second. All in favor of conforming?
I'm fine with that, of course.
Vote aye.
Aye.
Any opposed? Okay, Senator Servell, did you have additional?
I do, Mr. Chairman. We discussed this on the floor, but I think $1,000 is too low for a conspiracy. It's a really sad, pathetic gang. If after 90 days they only steal about $1,000 of stuff. And I think if we're going to have this increased sanction, it ought to be a higher number. I would move to amend the bill to a $10,000 threshold, which I think is a good 5. Okay, Senator Peterson says 5,000, so I'll move to $5,000.
Okay. Is there a second?
Second.
Okay, a motion and a second to move $1,000 to $5,000. All in favor of that amendment, say aye. Aye. Opposed?
No.
Okay. The chair's in doubt.
You still got to come to my side, too.
The chair's in doubt. Please open the roll. Vote green is a vote to take it to $5,000. The chair does not have good ears. Well, they might be pretty good.
Ayes 8, no 7.
Okay, so now motion to report and re-refers in order. Okay. Motion to report and re-refer to finance. All in favor, vote aye. Okay.
Ayes 14, noes
Thank you very
0,
much.
abstentions 1.
Okay. The next one on the list is House Bill 1931 from Delegate Durant. Is she here? Delegate Durant, your bill is similar to Senator Peake's 973 that reported from this committee 15-0 on a day when we probably had too much to drink. I just don't know. And then passed the Senate 39-0. What? Okay. Well, this is similar. What are the differences?
Thank you, Mr. Chair. It's my understanding that the language difference, I may have to phone a friend on it, has to do with regarding requirements for the expert witness. So I think that's the main difference with it.
Mr. Chairman.
Senator Servell.
Mr. Chairman, speaking of the bill, I think you might recall that we struck out part of Senator Peake's bill that had to do with the department wanted to be able to choose their own expert witness in some circumstances, and I went out and did some due diligence and did not like that change, and that's what we did on the floor. And so we need to conform hers to Senator Peak's bill to make it consistent. I would so move.
Okay,
That's fine.
all in favor of conforming the bill, say aye. Aye. Any opposed? Okay, are there other changes that are necessary? Report and re-refer is in order, and re-refer to finance. Okay, that's been moved and seconded. Are there, open the roll. Vote yea is a vote to report and re-refer. Okay. Thank you.
Thank you very much.
Delegate.
Ayes 14, no zero.
Delegate Williams, 2166. This was similar to Senator McDougal's 896. It was reported from this committee 8-7 and reported from Finance, and then the pass the Senate.
It's a fine bill. I hope you'll do it again.
It's similar to 896. What are the differences?
Could I call on the staffer to help me identify the differences? They're very similar.
You might want to pull the mic up a little bit.
Oh, I'm sorry. I don't think there's much difference in this 2166 with the Senate cognate. I believe the words are identical.
Mr. Chair, I know it is similar. Let me pull up the differences.
That's fine.
I'll second.
Motion and a second to conform to Senate Bill 896 from Senator McDougal. So all in favor say aye. Okay. This is the bill that adds petty larceny to the list of offenses included in the definition of racketeering activity.
Can I ask a question?
Senator Peterson.
And I may have to ask Senator Benjamin, but under federal RICO, is petty larceny a racketeering offense?
I do not practice federal law.
I mean, if I watch The Godfather, I mean, is it the petty larceny, is that going to trigger?
I just don't know. I'm sorry.
Rudy Giuliani going after the guy?
I'd have to defer to counsel.
I mean, Mr. Chair, I answered the federal offenses are typically bank fraud, mail fraud, wire fraud.
It's like the big stuff, right?
Right.
Not like stealing a candy bar.
Yeah, I don't believe they have a jurisdictional floor, but.
Mr. Chairman.
Am I missing something here?
Mr. Chairman.
Senator McDougal.
Mr. Chairman,
Senator
what
Peterson,
this
you through?
does is you have to have a combined amount of $10,000, but petty larceny is how you can get to that $10,000. So what this is going after are the groups that are coming into the state, organized larcenies where they go into different stores and steal up to $1,000, but do it in multiple stores. So that's where the organized part comes in.
Okay, Mr. Chair, if I might ask a question.
Senator Peterson.
And I'm not underestimating people stealing property, but RICO to me is like dropping a nuclear bomb on somebody. I mean, that's like, well, thank you.
Can I, Mr. Chair?
Hopefully Sasslaw doesn't have a hot mic right now, but, okay. That to me is the worst of the worst.
Mr. Chair.
Delegate Williams, sure.
Another thing that we're seeing is with the catalytic converter thefts. So when they steal a catalytic converter, it's not valued at over $1,000. But we have rings of people stealing $200, $300 converters.
Didn't we address that through some other legislation?
We did. That was more possession when it gets sold. This would address the ring of the criminal enterprise.
Okay, are there other questions? Are there motions?
Move.
They have to be report and re-refer.
Conform, Mr. Chairman. The difference is that the Senator McDougal's version had, or anything of value, wasn't just limited to proceeds, so it added anything of value.
So we haven't conformed yet?
Brilliant amendment. Move to conform.
We've already conformed, I think. So the motion is to report and re-refer.
So moved.
Okay, are there other motions? Then open the roll, vote yea is a vote to report and re-refer.
Ayes 8, no 7.
Ayes 8, no 7. The board bill is reported and re-referred. You've got 2167, which is similar to Senate Bill 1103 from Senator Stewart that was PBI'd in this committee. It's similar. Charles, do you know what the differences are?
So, Mr. Chair, the differences are, I'll say, largely technical. The Senator Stewart bill had version of like or franchise thereof, and the House version just basically says at the workplace of the same employer. It also defines what hospital is in the bill. It picks up a definition from the code and talks a little bit about more in the place of worship to include education buildings or community centers. That's the differences between the two bills.
Okay, this was the bill that said that it elevated the offense if it occurred in the workplace, wherever the workplace was. Is that correct?
That's correct, Mr. Chair.
Okay, and we were a little concerned because in the pandemic environment we've been in, the workplace for a lot of people has been the home. It could be almost anywhere.
It's a fair point.
Are there, do you want to, 30 seconds to tell us why we were wrong?
Well, I don't have a good answer for some of these questions, but I think that the idea was we wanted to increase the deterrent of committing gun violence in these particular areas. That was the goal. And so, as they say in court sometime, I'll leave it up to the committee.
Okay. Okay. Are there motions? Got a motion to report. Is this a bill, if it's reported, does it have to go to finance?
Yes, sir. Yes, Mr. Chair.
Okay, the motion is to report and re-refer to finance. Are there other motions? I don't think they're not paying much attention. Okay, the motion is to report and re-refer. This is identical to a bill we PBI'd before. What am I supposed to do? What am I supposed to do?
Mistrial.
Delegate, you're
I
allowed.
moved to mistrial.
All right.
I'd like another hearing.
Motion denied.
New panel.
A new judge.
Motion denied.
Oh, I've been enjoying your commercials.
Second.
Is there a second? Is there a second on the motion to PBI?
Second.
Okay, so the second, this motion takes precedence.
Thank you for failed to PBI.
All in favor of PBI, vote yay. Thank you,
We
Dylan.
like to
Ayes
provide,
9, no 6.
we like to provide parity with how we treated our Senate colleagues, so.
Okay, Delegate Brewer, thank you very much.
Mr. Chair, I think I have one more, but I might not. It's two.
Are you on the criminal law subcommittee?
I am, yes, sir.
Okay,
HB 2168.
2168.
It's the jerk,
Yeah.
the jerk candidates bill that we wanted to have jerk review or somebody from jerk be here,
Okay, right, okay, yeah.
if that's okay.
If he's on the subcommittee, he's got two additional after this?
I'm gonna ask you to pass by on 2171.
2171, I think, has to go to finance, doesn't it?
No.
It shouldn't.
Okay, so we can do that on Monday.
Yeah.
Okay, 2168.
I presented this earlier. This is the breach of Cannon's report that we wanted to have jerk be here to see what they thought about it.
And Mr. Chair,
Senator Edwards, yeah.
I believe there was a adoption of an amendment that struck essentially the second enactment clause and replaced it with that the provisions of this act shall apply only to disciplinary actions taken on or after July 1, 2023.
That's right. I think it's
Senator Serval and the committee adopted that.
And I saw it as friendly.
Okay. And this would basically require publication of judicial disciplinary matters.
It would be included in that annual report that we received.
What's your pleasure? Committee operates on motion. Are there other motions? Open the roll of vote. Yea is a vote to report. We didn't have a Senate cognate.
Ayes 10, noes 5.
Ayes 10, noes 5. The bill's reported. Okay, that's it?
Thank you.
Okay, back to our order now. Had Delegate Brewer, 2290. Is Delegate Brewer here? Delegate Weber, 2360. Okay, this bill was similar to Senate Bill 1353 from Senator Norman that was PBI'd in this committee 8-6 with one abstention. It raises from 5 to 10 years a minimum for a second subsequent offense, a mandatory minimum sentence for use or display of a firearm during the commission of some offenses.
Madam Chair, Mr.
This- it
Chairman,
says it's
I
only-
move to report it. It's an opportunity for you to correct your mistake.
It's only similar to Senator Norman's bill. I wonder if there are differences that are worth noting.
Mr. Chairman, this is actually a little bit narrower than Senator Norman's bill. It does increase the mandatory minimums for the use of a firearm during the commission of a felony from 5 to 10 years on a second offense.
Only the second offense.
And that's what the bill does. Senator Norman's bill also increased some mandatory minimums on firearms on school property offenses.
Okay, this is a bill that also has to go to finance if it's reported. The corrections impact is 48,000 and some change. I assume this is incorporated somewhere in the House budget?
Yes, sir.
Well, it has to go to finance.
Mr. Chair.
Mr. Chair.
Is there still a mandatory minimum in this?
It increases okay, Senator, we've got a motion to report. Is there a second?
Mr. Chair, I have a
Got a
question.
motion to report and a second, Senator Morris.
Got a question. This train is moving awful fast. Your legislation, Delegate Weber, you want to increase to 10 years for a mandatory minimum sentence for the use of a firearm in the commission of a felony, correct?
Yes, sir. On the second offense.
Second offense. And you also realize that this would catch up those individuals that did not actually use a gun, but were there at the robbery, for example, and were convicted as a principal in the second degree. You agree? It would catch that person.
I'm not a lawyer, sir, so I don't know. But if you commit a felony once with a firearm and then you're convicted again with a firearm, there seems to be a pattern that has arisen.
Let me ask a different question, Mr. Chair.
Senator Morrissey.
Do you believe that with all the vetting that we do with judges in the Commonwealth, whether it's in the General District Court or circuit courts, but particularly in a court of record, that those judges have the ability, wherewithal to examine a case on a case-by-case basis and determine whether or not a mandatory minimum is applicable, much less a mandatory minimum of 10 years?
I would say that the judge's discretion, the judges will do what the judges will do. I just feel that, so for instance, in my county, we had a man who came home for lunch and was gunned down in his yard because a man who had committed 107, was charged with 107 different felonies or court whatever, and they should have been in jail. And they weren't. And he had a record. And basically, sir, I guess the biggest reason for even bringing this up is this, right? I understand where the fate of this legislation may be, but we oftentimes, when we start talking about violence in our streets and violence in our communities, one side always talks about a gun. One side starts talking about, at least in my mind, the reason for this piece of legislation is to begin the conversation where we start talking about the fact that we have people who, there's a saying, and it's, you never learn from the second kick of a mule. And you have people that have committed a crime, and again, they're out on the street. They've committed a crime. Again, they're out on the street. Those are the people that commit a very large portion of the violence in our society today, whether it's in the inner cities or a farmer coming home from work and gunned down in his yard.
I agree.
And so, respectfully, Senator, it's those folks, at least the reason I agreed to carry this bill, is those folks that have done it again and again deserve to be in jail for longer than 5 years.
Final question, Mr. Chair.
Senator Morrissey.
I shared this, and I'm interested in your opinion with my colleagues before. what I consider a problem with the mandatory minimum. Young man, Johnson, 17 years old, was at a summer party with two adults, and they pulled a gun and they robbed the people, the 7 people. And those 2 adults pled guilty to 12 and 7 years respectively. He didn't. He said, I didn't do it. I was there. I didn't even know what they were going to do, but I was there. No, I'm not pleading guilty. Goes to trial. He was found guilty of this as a principal in the second degree, the 7 robberies, and the use of a firearm. And the judge, when he gave him 33 years, 3 years on the first firearm and 5 years on the remaining 6, for 33 years, said, I don't want to do this. I have to do it. I can't believe I've got to sentence you, that's his words, to 33 years. Your bill would now require that that defendant gets 63 years. Do you see a problem with that?
I would say to the gentleman that particularly in that particular instance, if that person had done the crime before, then perhaps they need to avoid that situation again.
Okay.
The issue that I have particularly with that is that person that's one instance. We're talking about people that have come back again and again and again.
Thank you very much, Delegate.
Thank you, Senator. I appreciate the questions.
Okay, we had a motion, I think, to report. Substitute motion.
PBI.
Okay, is there substitute motion takes precedence. All in favor of the substitute motion will vote green.
Where's law and order's asking?
Ayes 9, no 6.
9-6. Okay.
Thank you, Mr. Chairman.
Thank you. Thank you. You need to chair. You need to take up these 3 bills, this order, and then this bill, okay? And I'll be right back.
All right, the next bill would be Senate Bill, House Bill 1892. Is that right? No. I'm sorry, 2013. Senate House Bill 2013. And that would be Delegate Adams.
All right, thank you, Mr. Chairman, members of the committee. House Bill 2013 is the bill we passed to make changes to the law governing the revocation of probation or suspended sentence. It is the same bill, admittedly, I can see it up front, the same bill that this committee saw last year, and it's in the same form that you saw it last year. I will say this, we introduced it as hopefully compromise legislation. It's always been viewed that way, recognizing that there is a diverse opinion on how to deal with this. But by way of background, the committee will recall it was in the last term that this area of the law was substantially changed to set up a series of categories for violations, whereas before a judge could make a determination that someone has violated the terms of their suspended sentence or their probation. They could revoke any or all of that sentence. Now you have technical violations and non-technical violations, and then you have and most descriptions fall under the technical violations. So the bill before you now does not it doesn't repeal what was done in the last term. It keeps the structure of technical violations and non-technical violations, but it redefines the technical violations to omit some of the what folks thinking along the same lines as me, more egregious offenses like absconding. That was one of the most challenged portions of the law when it changed, is that there could be an allegation that someone absconded that would be treated as a technical violation, which means that there's no new imposition of sentence. The judge has no ability for that. And I will inform the members of the committee, one of the things I learned following the legislation from last year was that absconding is not just a wide open definition. The Department of Corrections, there's actually regulatory authority on this. It has specific steps that a probation officer must follow. And so that's one, but there were others that were removed. But that's on the on the last lines of the bill, you can see that there's still technical violations include most other type of offenses, so those are still there. There's also a change that is suggested about what the court can do when the defendant has violated, and I'm just trying to get the exact language here, an earlier part of the statute. I think what I'm trying to say is that there was, as a concession, there was also a limitation on how much the judge could reimpose. And so for any felony offense, it's only up to 2 years. So that's in the first part of the bill. And if it's a Class 1 or a Class 2 misdemeanor, only up to 2 years. So we think this is a reasonable suggestion. You know, there was initially a request that it be passed by for the day. I understand that can't happen because of the deadline.
Mr. Chairman.
On the re-referral.
Mr. Chairman.
Yeah.
Thank you, Mr. Chairman. And I spoke to the patron of the bill, and he's been having some discussions which he think might bear fruit with somebody whose opinion I trust on this. And what I would propose that we do to keep a discussion alive, given the deadlines we're facing, is to strike basically lines 83 through the balance of the bill, and then add a reenactment clause of the bill. And that way it'll be, I think the patron would probably be in the mood to put the thing into conference, keep this discussion alive for another week.
Which lines you want to strike?
Basically from line 83 through the balance of the bill, and then add a reenactment clause.
Everything below lines 83? Right.
Yeah.
And so what's left then? What's left on the bill?
Mr. Chair, what would be left is just whatever in the first section, 19.2303.
What's that again?
What would be left in the bill, it was whatever is in the first section, 19.2303.
And Mr. Chairman, it would be subject to reenactment in the future by future General Assembly, so it basically wouldn't leave anything, but it would leave us a vehicle to have a discussion. That'd be my motion.
Is there a second to the motion? All in favor of the motion, say aye. Aye. Okay, okay, let's call the roll then on the amendment to strike everything below line 83. Okay? All in favor of the motion, vote aye. All opposed to the motion, vote no.
Ayes 9, no 6.
Okay, 9 to 6.
Thank you, Mr. Chairman. I would move the report and re-refer the bill to finance.
Okay. The motion's been made to report and refer the bill as amended to finance. Does it need to go to finance?
They asked for it, Mr. Chair, so.
Mr. Chairman, if
Mr. Adams, first of all, the
I was just
patron,
going to say with regard to the need to re-refer it, if the balance of the bill is struck, I mean, I think that's where the indeterminate nature of the financial consequence is identified in the fiscal impact statement. So I'm not sure that, I'll defer to counsel, but I don't believe what's left in the bill will produce a additional cost to the Commonwealth. It would reduce cost to the Commonwealth.
how about why don't we carry it over for the year?
Mr. Chair, typically if finance asks for a bill, even if we do strip out the fiscal impact, we send it up there with a recommendation. Yeah.
All right, okay, the motion's been made to report and re-refer the substitute to finance. All in favor of the motion, vote aye. All opposed, no.
Ayes 14, no 0, abstentions 1.
Okay,
Thank you, Mr. Chairman.
Senator Edwards. Thank you, Delegate. Don Scott. I know. Senator Delegate Scott, Delegate Scott here?
Yeah, Don.
Oh, I'm sorry.
Phil, you got two delegates.
23-7.
Good-looking one.
Okay, this bill is similar to Senator Servell's 841 that reported from this committee 14-0 and passed the Senate 38-0. This bill is just a VASAP bill. It says it's similar. Charles, what are the differences?
The differences between this bill and the Senate bill, there's two differences. One, the Senate changed the language regarding wet reckless from alcohol as a factor to a person must be charged with a DUI violation. And the second thing is the Senate bill allowed for the request to be made for the local Commonwealth attorney to serve on the board. The House version required basically, said it had to be asked.
Do you have any objection to us conforming this bill?
We can conform, and I've talked to Senator Survey, and we'll work it out.
I'll take a motion to
So
conform the
moved.
bill. Okay, is there a second? Okay, all in favor of conforming this to Senator Servell's 842 or 841, say aye.
Aye.
Any opposed? Okay, the bill's conformed to 841. Does it have to go to finance?
It does not, Mr. Chair.
Does not. So is there a motion to report the bill? So there's a motion and a second. Are there other motions? If not, open the roll. A vote yea is a vote to report.
Ayes 15, no zero.
Okay, ayes 15, no zero.
Thank
Congratulations,
you, Mr.
Delegate.
Chair and committee, for passing Senator Stewart's bill.
House Bill 2129. Delegate Delaney. 2129. I'm sorry, I just had a list of people on the subcommittee. I just said numbers.
I appreciate you calling my number. Thank you, Mr. Chair. Thank you, committee. So that bill before you relaxes the standard to be met for the testimony of minor victims and witnesses of crime to be admitted into evidence via two-way closed-circuit television. Additionally, the bill revises the age at which these standards apply from a child who was 14 years old or younger at the time of an alleged offense and is 16 years of older at the time of trial to all minor children. So while CCTV testimony is already permissible in Virginia, the current standards is incredibly difficult to meet and does not align with the best practices for trauma-informed interactions with minor victims and witnesses to crime. For children who have been victimized or assaulted, testifying in front of a full courtroom under the glare of their alleged abuser is often re-traumatizing and additionally can lead to unsuccessful prosecutions. If the child is unable to testify in person, the current Virginia statute is so restrictive that CCTV testimony has only been used successfully only one time in my locality in Fairfax County. In this case, a young girl was finally able to be permitted to use CCTV after breaking down repeatedly in court while testifying against her dad, who had sexually assaulted her. The prosecutor's office ultimately won a guilty conviction, and it was a small measure of justice for her. But seeing this option kept from so many children and the resulting needless re-traumatization has highlighted a problem in Virginia that desperately needs fixing. The bill solves this problem by relaxing the standard to align with the Supreme Court precedent established in Maryland versus Craig. By expanding access to CCTV testimony, Virginia can become more trauma-informed in their approach to victims and improve trials, all without sacrificing the core values of our justice
So if I
system.
can cut to the chase.
Yes, Mr.
Right now,
Chairman.
if you're under 14 and if you're under 16 at the time of the trial, you can testify by a closed circuit. If you're under 14 when you're a victim.
So, yeah, Mr. Chairman, I would say that currently, so this bill accomplishes two things. It addresses the current 14 at the time of the offense or 16 at the time of trial. It will now extend that to all victims that are children, so under the age of 18. What it also does is it lowers the standard by which the level of trauma, currently severe emotional trauma, must be demonstrated in order to even ask the judge for this consideration. We're instead lowering that to more than de minimis, which is specifically from the Maryland v. Craig ruling. So it would not be an issue with Fourth Amendment. We would have the opportunity to align that language with that Supreme Court ruling to lower that standard of trauma as it is related to being.
Is that term de minimis defined anywhere in the Code of Virginia?
We discussed that in our courts committee, and I don't believe the word de minimis is, but I think that it obviously has enough precedent in the rulings that use that kind of language that we're imagining that would be very clear if it were to ever be challenged, that it is the exact language that was from the Maryland v. Craig ruling.
Okay. Okay, Senator Morrissey's got a question.
Delegate Delaney, are you familiar with the Sixth Amendment to the United States Constitution?
I am. I would say to the senator.
And you would agree that the Sixth Amendment to the United States Constitution absolutely, with unwavering certainty, guarantees a defendant the right to confront his or her accuser face to face.
Mr. Chairman, what I would say to the senator is current law
Now,
allows.
excuse me, I just want to ask you, would you agree that that is what the Sixth Amendment says?
Mr. Chairman, I would say that the Sixth Amendment, I don't have the exact language of the Sixth Amendment to say exactly if those are the words that it says guaranteed face-to-face. It's clearly been interpreted by the Supreme Court that there are provisions by which this type of remote testimony is permissible. And so people who are much more qualified than me that sit on the Supreme Court have made the ruling that if the trauma is more than de minimis, the child should have this option to petition the court for this to be considered.
Follow-up question. Would you agree that one of those men on the Supreme Court would be Antonia Scalia?
Mr. Chairman, I'm not sure how that's relevant to this piece of legislation.
Tell me if you agree or disagree with what Justice
Senator
Scalia
Morse.
said. Mr. Chair.
Senator
Tell me
Morse.
if you agree or disagree with what Justice Scalia said. First of all, when he enunciated, no liberal, mind you. And first of all, reciting the Sixth Amendment and stating that in all criminal prosecutions, the accused shall enjoy the right to confrontation, to confront the witnesses against him. He went on to say the following. The Sixth Amendment provides with unmistakable clarity that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. The purpose of enshrining this protection in the Constitution was to assure that none of the many policy interests from time to time pursued by statutory law could ever overcome a defendant's right to face his or her accusers in court. Would you agree with that statement by Justice Scalia?
So, Mr. Chairman, again, as a non-attorney, I don't believe that defending this bill necessarily qualifies me to agree or disagree with a Supreme Court justice's opinion. It would sound that, though, that the senator disagrees that our current code is constitutional because our current code allows a prosecutor to ask a judge for this consideration if certain criteria are met. We are looking to align that criteria with a more trauma-informed courtroom because we know much more about how children respond to trauma than we did when that code section was written, and we are aligning it to a Supreme Court ruling that clearly defines the standard of trauma that needs to be met for this to be considered constitutional.
Follow-up question, Mr. Chair. Assuming assuming arguendo that there is trauma for a witness to testify, whether it's a murder case, an arson case, or a sexual assault case, assuming that there's more than a modicum of emotion and trauma there, which trumps which? The Sixth Amendment enshrined in the Constitution, or as you referred to it, the traumatization of a victim? Just that answer. Which trumps?
Mr. Chairman, that is for the judge to decide. That's why we are allowing this petition to be considered. This does not allow children to default testify via CCTV. This allows prosecution to ask the judge for consideration that if these conditions are met, if the judge hears all of that evidence, the judge would be having the capacity to make the decision as to whether or not that's an appropriate ruling.
Follow-up question, Mr. Chair. Have you read any of the 3 Court of Appeals decisions dealing with children recanting their testimony because of inadequate examination, including Commonwealth versus Michael Haas, Commonwealth versus David Gingria, and Commonwealth versus Esther Thorne? Are you familiar with any of those cases? Recent COA cases where children that grew into adults recanted their testimony.
Mr. Chairman, what I am familiar with is the language in Maryland v. Craig, which is the language that we are using in this bill. What I'm also familiar with is the evolving body of brain science about what trauma does to children and the evolution of the trauma-informed courtroom. And what I'm familiar with is the enduring trauma that a child experiences when they're in a courtroom not only affects them for the rest of their life, but it affects the quality of their testimony. It creates a situation where if you've got a child breaking down on the stand, that's not necessarily going to be good for a defendant either. But it also isn't necessarily the most quality testimony, because when a brain is going through the level of trauma that this bill would prevent, the ability to recall facts and information is diminished. We are aligning our courtroom proceedings with the new knowledge that we now know about how children and people react to trauma, and creating, I think, a more just system.
Thank you. Follow-up question.
Senator Morsi.
Were you aware that Maryland versus Craig was decided in 1990, 2 years before the seminal decision in Crawford?
Mr. Chair, I'm not sure my intimate knowledge with Maryland v. Craig really applies to the content of my bill.
Yeah,
Isn't Craig-
Senator Morsi, come on. We've got to go back in session at 3:30. She's not a lawyer.
All right. Thank you, Mr. Chair.
Senator Norman.
Thank you, Mr. Chairman. I'm not much of a lawyer, but I tried this case about 10 days before we came up here in session and made this very argument. First of all, my recollection is that Scalia's opinion is a minority dissenting opinion. Number two, Virginia's statute has been attacked many times for the tender age of a victim who's testifying remote, and as of today, it remains constitutional. It has not been declared unconstitutional. And that's taken into consideration the Sixth Amendment on the right of confrontation, that in Virginia they have made that an exception which has not been declared unconstitutional. The last point I would make is I think 18 is too high a number.
Senator Sasslaw. Senator Sasslaw, did you have something you said?
No, I'm going to be reported.
Senator Morsi's got a question, and then Senator Sasslaw.
I have a question for counsel. Having evaluated this case, can counsel tell me whether or not they are certain that this legislation is constitutional?
Mr. Chairman, the last time that I, as counsel, gave that kind of an opinion, then Senator Cuccinelli pointed out that a law is not unconstitutional until a court declares that it's unconstitutional. And I remembered that lesson. The prevailing analytical question for that would be, what did the framers intend? And so I can tell the committee that there is no doubt that what the framers intended when they guaranteed the right to confrontation was face-to-face confrontation. And they did it because it's harder to tell a lie to somebody's face than to do it behind their back or on a video. But that is simply a prediction of what would happen should the statute be challenged. As of now, I can't say it's unconstitutional. Nobody but a court can.
Mr. Chair.
Senator McClellan.
Question for Charles. Is it still the practice of legislative services that if a bill raises constitutional questions, that they will notify the patron of that?
Mr. Chair, I would answer the question as yes.
Mr. Chair, question for Delegate
Senator
Delaney.
McClellan.
Did you receive such notification?
Mr. Chair, I would say to the Senator, I did not.
Thank you, Mr. Chair.
Okay, we didn't have a Senate bill like this. We've got some impatient people up here, but Jeff, you want to?
Just Jeff Hayslip with the Virginia Association of Commonwealth Attorneys. We support the bill. We think Maryland v. Craig, the court painstakingly, and albeit before Crawford, painstakingly went through the analysis of the state's requirement or duty to protect the child victim versus the Sixth Amendment right to confrontation. And this bill tracks that exact language.
I have a question to, are you aware
Senator
that
Edwards.
is more than de minimis standard anywhere in Virginia code?
I'm not aware where it is any definitional section of the code, but it's certainly used and understood.
We've got to move along.
Okay, there are more people that lined up behind you. You got about a minute each,
Sure.
okay?
Okay. Any questions? Any more questions?
No.
Ma'am.
Thank you.
Hi there, Mr. Chair, members of the committee. My name is Lisa Sales, and I'm here to read to you today a child victim statement because the Zoom is down. This is from the child. I wanted to do closed circuit television, CCTV, because I was scared to face my dad in court, face to face. The CCTV helped me calm down, but I was still a little bit scared to testify in court. But it helped me face my fear in court. I was able to testify much easier, and it helped me calm down almost all the way. I was glad that I was able to use the CCTV in court. I think CCTV is important because it can help kids face their fear of testifying, and they can go home more stress-free. They can go back to their lives. I think all kids should be able to use CCTV. More kids should be able to. It was hard to talk to my mom about what my father was doing to me.
And I apologize.
That's okay.
We only have about 10 more minutes before we have to go, and we've still got one more bill that has to go to finance. So I'm going to limit it to 30 seconds from here on out.
I'm sorry, what was the age of the witness? Age of.
Rob's plus 8, okay.
Mr. Chairman, members of the committee, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. Keep it brief. We support the bill.
Okay, thank you, sir.
Hello. I'm reading for Amy Walker, the director of the Arlington Alexandria CASA program. For more than 15 years, I have worked with vulnerable populations. I have never encountered a child victim who did not experience fear or trauma having to testify to their abuse in court, no matter the age. I would ask you to imagine an experience for a 12-year-old whose father insisted that his son testify in court so he could stand him down.
Ma'am, you're out. Could you provide us in writing the testimony? That'd be fine. If you provide it in writing, that's fine. 30 seconds each, okay? Please.
Mr. Chairman, Catherine Ford with the Virginia Victim Assistance Network, representing victim witness advocates around the state, and we support the bill.
Okay, thank you, ma'am.
Good afternoon, Chair Allison Powers from the Indigent Defense Commission. We have several concerns about the bill, one of which is the constitutional issue that has been raised. I think there's been a misunderstanding of the holding of Maryland v. Craig. It does talk about a de minimis standard, but doesn't actually reach whether that is constitutional or not, because the provisions that they were addressing were much higher than that. This is currently was used 136 times in 2002, so we have some concerns about if there's a gross expansion, if you've got two trials going on at once in different parts of the state, whether we're going to infringe on people's rights.
Thank you very much.
Thank you.
Thank you. Rob Pocahontas, Justice Forward. We oppose the bill for the same reasons that the VIDC does. We share the constitutional concerns. We also think this is a solution in search of a problem. Courts are getting to use the CCTV already, as Allison mentioned, 136 times last year. The standard is working, and so we would oppose the bill for that reason.
I move
Thank
the
you.
bill be reported.
Substitute motion.
Substitute motion.
I'd move that we amend the age to 16 or younger.
That's fine.
Substitute motion is to amend the age to 16 it's 14 now. She wants to move, her bill says 18. The substitute motion is to amend the age to 16. Do you understand that?
I consider that a friendly amendment, Mr. Chair.
Okay. Is there a second on that amendment?
Second.
Okay, all in favor, say aye. Aye. Any opposed? Okay, appropriate motion would be to report and re-refer to finance. Okay. Is there a second? There's a second.
Mr. Chairman.
Other motions, yes.
Can I just say that this is a significant piece of legislation, and giving it 15 minutes in committee is not the right. I understand the time constraints, Mr. Chairman, and this is why, this is not a kind of bill you do in short session when we have these kinds of time constraints, because this affects a lot of cases and a lot of people's lives. These result in a lot of false confessions. There's a lot of very technical legal issues wrapped into this, and we're doing it really fast, and that's when we mess up, and that's what I'm really worried about. And because of that, I can't support it in this posture right now, because this is going too fast.
I move we pass the bill by indefinitely.
Is there a second on that motion? Motion to pass the bill by indefinitely. We've got a motion to pass the bill by indefinitely. It's been seconded. That's a substitute motion. It takes precedence. A vote. Yay is a vote. Pass the bill by indefinitely. Open the roll.
No.
Open the roll, please.
No, this is a.
Pass by indefinitely. That's substitute motion.
Ayes 5, noes 10.
Okay, ayes 5, but noes 10. Now we're back to the main motion. That's to report and re-refer. Open the roll, please.
Ayes 10, noes 5.
Okay, your bill's reported and re-referred. Okay, Senator.
Thank you.
Or Delegate Bell, I think we have, is that 2398? Do you think we can do this?
I would like to start, and I don't know, it's, Mr. Chair, this is a bill that council was kind enough to spend a significant length of time on and has a different approach. They have a substitute they would like, yes, sir.
Have you seen the substitute?
Oh, yes, sir, no.
What do you think about it?
No, I think that, again, there's, in the big picture, we have conduct that's falling between extortion on one side and forcible rape, sodomy, object penetration on the other. This takes the extortion approach. I think we've looked at both of them. I'm fine with it. I mean, if.
Okay, and do I have a motion to adopt the substitute? Do I have a second? All in favor of adopting the substitute, say aye.
Aye.
Any opposed?
Sorry.
Okay, does council want to explain the substitute, what that does?
So, Mr. Chair, this, as Delegate Bell just said, this takes the approach of essentially equating this to more like extortion, because under current law, extortion needs to be accompanied with a pecuniary gain. This basically says that if any person who maliciously disseminates or sells or maliciously threatens to disseminate or sell a video image of someone in a state of undress and then basically demands sex for it and then accomplishes that is guilty of a Class 5 felony sexual extortion. If it involves a minor, it is then punishable by a felony of 1 to 20 years in prison. And essentially, that's what the bill does.
Does anybody have any questions or?
Mr. Chairman.
Senator Serville, then Senator Morsi.
So I think the one question I have is it appears that basically this is extortion by sexting or something like that.
By revenge, I'd say the gentleman, it's the revenge porn statute,
Okay.
except only if it's you or a family member, not just any old
Got it.
unrelated
Mr. Chairman,
issue.
further question?
Senator Serville.
Okay, so we got extortion by revenge porn. I appreciate that part of it. My question is not about that.
Yes, sir.
But this also appears to require listing on the sex offender registry on line, what it is,
Yes, sir.
line 28, is that right?
Yes, sir.
That's correct, Mr. Chair.
Okay. And so, Mr. Chairman?
Senator Serville.
So we don't require listing on the sex offender registry for revenge porn right now, right?
I don't think so.
Mr. Chairman, I'll have a motion with that at some point, but we might have some further discussion about that.
Senator Serville. Delegate Bell.
But we kind of leapt right into it, which is fine. Everybody's in a hurry. The issue is someone is having sex that doesn't want to have it. And so initially, in the first draft, which you saw pass out of the House, we just made it part of rape. We said if you force someone to have sex and she doesn't want to, it's against her will. There's certainly an argument that it's the same as rape. You're having sex. This isn't extortion for money. She's forced to have. You're forcing someone to have sex who doesn't want to have it. With that said, I understand that this is a bicameral legislature, and if you decide that that's the way this is going to move out, that's the way it's going to move out. But that's the basis for saying it ought to be a sex offender registry offense.
Got it.
Mr. Chairman, don't we already have
Senator Morsi had a question before you, Senator Edwards. I apologize. Okay.
Thank you, Mr. Chairman. Delegate Bell, would the following be captured with your legislation? A man or woman were dating and engage in consensual sexual intercourse, and they take a consensual video. Later, that perhaps after they break up, perhaps when they're still dating, disseminates that information. Okay? Doesn't ask, doesn't threaten to do it, but just disseminates it. Is that person, either the man or the woman who disseminates that video, captured with your legislation?
I don't believe so. They would be captured by revenge porn, perhaps. The actual dissemination would itself be a misdemeanor crime, and they could be punished for that. But in terms of trading it, threatening that if you don't have sex with me, I will do this, that's what this, because it's in the, now it's now in the extortion context.
That's
Now,
correct,
if
Mr.
counsel
Chairman.
feels
The
differently,
bill requires that they do it with the intent to coerce someone into having sex.
Final question.
Yes, sir.
Senator Morsi.
Is the crux of this bill, when you say maliciously disseminates, is that what the Commonwealth would have to prove? We're already past the point that the video has been distributed to whomever by either the man or the woman. But where the rubber hits the road on this bill is the word maliciously. Is that right?
I think, actually, I still think that's probably more in the revenge porn context. The key part here is not that you are doing it however maliciously or harmfully or wickedly. The issue is you're doing it to coerce someone into having the kinds of sexual relations with you. That's what makes this different and why we think that it's worse. The fact pattern, and Mr. Chair, you're very busy. The fact pattern was just that. It was a high school student, and she willingly provided the images, and then later he used that to coerce her into at least attempting to do something that she didn't want to do.
And Mr. Chair,
Senator Edwards has a question.
Don't we,
Charles,
don't we already have an extortion statute that would cover something
Mr. Chairman,
like
we
this?
do, but that requires a pecuniary benefit, extortion
Money.
for pecuniary benefit.
it requires for money. And one of the reasons why we decided this approach may be better than what the House, and I don't want to say better, but a different approach than the House did was the concern in the House bill was, what about the attempt? Because it was essentially equating this to be rape. And this bill allows for somebody who threatens to send the image and demand sex can be prosecuted for the attempt of that violation. So if someone receives a threat, they can call police and have police intercede at the attempt part. Where the House version, it did seem difficult to say that would be attempted rape just by saying, I'm going to, unless you have sex with me, I'm going to post this photo, which I think this version tries to capture that conduct in a more succinct and better manner.
Mr. Chairman, wouldn't it be better to use the existing extortion statute and put something other than just pecuniary?
Mr. Chairman, we did think of that and decided this was a better approach.
Okay. The reason I asked the question, I actually prosecuted one of these under the federal law. And that's another thing, years ago. So.
Okay, we haven't heard this bill before. There are a couple of witnesses.
Mr. Chairman,
Senator Surville,
thank you. I have a question for the patron.
you had an amendment too at one point.
Yeah, I was thinking about that.
But now you just have a question.
Well, I have a question that might lead to a different amendment,
Okay.
too. I mean, one of the things that worries me about this is that, obviously, if these people have a relationship and they're exchanging pictures or not exchanging pictures or whatever, there's been things going on. Right. And obviously, when relationships break up, things go bad and people start saying things. One of the things I worry about with this is that the alleged extortion could be purely verbal, which is a he said, she said. So if the alleged victim comes and says, he said this for the picture, then you're all of a sudden in this jacked up felony territory instead of in misdemeanor land, right? And so would the patron consider it friendly if it had to be a written extortion as opposed to a verbal one? Because that, to me, would be a lot less subject to being abused than, the victim coming forward and saying, he said this.
I think that would very significantly reduce the instances where this conduct would be addressed by the bill. What I mean is, he says, if you don't do this, I will do that. And then she has sex with him, not wanting to, but because she's afraid he will do something. In the current law, if it's not physical, the threat, intimidation, is it ruse? Okay, threat, intimidation, ruse language, which is in all of our forcible sex statutes, it does not cover that because there's no physical. He doesn't say, I'll hit you, that's covered. I'll punch you. All these other oral threats we allow to arise in that context, and we say it's a proof problem, it's a rape problem. I don't see how to get there. You're going to do what you're going to do, and it may be that there's no circumstance under which you would pass this, but I'm afraid that would do so much, it would restrict it in so many ways that it probably would not address what the circumstances from which it arose and in the circumstances it's going to arise. I understand what you're saying, though.
Okay, thank you, Mr. Chairman. I'm going to keep thinking about it.
Senator Surville, okay. Then we've got some witnesses back there. I'd ask you to keep it brief. We've got about a minute before we have to go back to session.
Certainly. Jeff Hayslip, Virginia Association of Commonwealth Attorneys. We support the bill.
You've seen the substitute, Jeff?
Yes, I have, and I want to thank the staff for their work on that. It did happen in Fluvanna County, this fact scenario. A young lady sent pictures to someone she thought cared about her. He then threatened her that he was going to put them on Instagram, Facebook, everywhere if she didn't meet him at a certain place at the school and perform a sex act. So looking at the bill, nothing fit. So this is what we came up with. I will say our first draft was in the light of exactly what staff came up with as a substitute. So we're certainly fine with that. Thank you.
Thank you. Yes.
Mr. Mr. Chairman, members of the committee, Jonathan Iglesias with the Virginia Sexual and Domestic Violence Action Alliance. We do support the bill and the substitute. We believe that this is a way to modernize the sexual assault statutes so that the crime fits what the law actually says and therefore is more easily prosecutable. We see this as reconciling what victims' needs are in the field, what we hear every day from victims.
Thank you very much. Yes, sir.
Morning, Mr. Chair, members of the committee. Patrick McKenna for the Virginia Coalition Against Human Trafficking. We support this bill and thank the delegate for bringing it.
Okay, thank you very much. Okay, the appropriate motion would be to report and re-refer or something else, because this bill has to go to finance.
Move to report and re-refer.
And something else. Or something else.
Whatever that else may be.
Yeah. Okay, are there other motions? If not, open the roll. A vote yea is a vote to report and re-refer. Understanding that we had to cut.
I understand.
Had to do a whole lot in a very short period of time, and things could change.
Senator Serban.
As it heads upstairs, I understand it. Yes, sir.
Ayes
Thank you.
12, noes 2, abstentions 1.
Okay, thank you very much.
Thank you, Mr. Chair.
The plan is to come back here after we do whatever we're going to do on the floor. I assume we're going to take another break in an hour or so, and then we will try to finish the bills.